A common myth about estate planning is that if you're married, your spouse automatically inherits everything when you pass away. But in reality, that's just not always the case. Hi, my name is Audra Platt. I'm one of the estate planning attorneys at Pittman Law Office. And when you pass away without a will, known as dying intestate, state laws determine who inherits your assets. And in many states, a surviving spouse may have to share with children. So this is more prevalent in blended families. For example, if the deceased person has children that are not the surviving spouse's children, that can mean that the surviving spouse only gets half and the deceased person's children gets the other half. So this can cause a lot of unintended consequences for the surviving spouse. This is particularly true when we have minors. There's a lot more laws in place when we do have minors involved, but it's not just as if we have minors. So it's very important to understand that just because you're married, it does not mean that your spouse automatically gets everything. So estate planning ensures that your wishes are met. So through a will or a trust or beneficiary designations or simply how your assets are owned. So a big thing that we ask when you come in and see us is, how are your assets owned? Are they owned jointly? Are they owned individually? Do you have beneficiaries on your accounts? Those are all things that we look at to make sure that your wishes are met. So making sure that you understand how your assets are owned, who is named as beneficiaries on them, and then does your will and your trust align with your wishes are huge because, again, not everything goes to your surviving spouse. Now, if you own an account with a surviving spouse, you die, yes, the account goes to your spouse. You own a home as tenants by the entirety with your spouse. You pass away, yes, the house goes to your other spouse. But just making sure and following up that this is actually done will make sure that your intentions are actually honored. The second myth that I want to bust today is that estate planning is just for the uber wealthy. And this one is definitely not true. And a prime example of this is actually last week, I was talking with a potential client. They came in, they had a complimentary consultation, and they were telling me that probably about 20 years ago, the wife got in a very bad accident. She got very ill. She was in the hospital for over 2 years. She was completely incapacitated, unable to make financial and medical decisions for herself. Now, unfortunately, these clients did not have proper estate planning done at that time. And that spouse that was okay, not in the hospital, had to pay thousands of dollars to go and get a guardianship to be appointed to be the sick spouse's guardian, where he was able to make all medical and financial decisions for this person. So instead of the spouse being at the hospital caring for that sick spouse, they had to be at the courthouse getting a guardianship, paying thousands of dollars that obviously was not intended for. So I don't care if you have $5 to your name or you have millions of dollars to your name. Having the proper estate planning documents in place will help save your loved ones from a lot of unintended consequences. Estate planning is not just about moving wealth from you to your beneficiaries. It's looking at you holistically, making sure that you are protected whether you're incapacitated or after you pass away. So if you want to make sure that your plan is in place or establish a plan, we do complimentary consultations at Pittman Law Office. Feel free to give us a call, but always look at our YouTube channel. We have a ton of great resources on there, and also our website and our Facebook page. And again, my name is Audra. Thank you.